Hi, Professor. Myself, Abdul Samad Ansari. My student ID is 4386229. And the topic of our presentation and the case study is the dispute between two parties. And one is named as a man, David McQueen, and the other is the provincial lake of Alberta. This case was heard by Alberta Court of Queen's branch, and this case was heard on 11th of December 2000, and this case was dated on Alberta 21st of March 2001. And there are two parties in this case. One is the plaintiff, which is David McQueen. Plaintiff refers to a person who accuses someone for the case, and the other one is defendant, which is the province of Alberta of Calgary. So there were also two appearances in this case: Robert D. Hart from the plaintiff side, and Mr. G. Allen and Mikhail Kiosi, Mrs. Jennifer Stangel from the defendant side. So moving on to the next part of this thing, as I introduced you with the name of the parties, there let me give you a brief overview of this topic. So on June 25th, 1994, David McQueen, in the company of his three children, visited Sikome Lake Provincial Park near Calgary, Alberta. The lake is a man-made swimming facility owned by and operated by the province of Alberta. That's why he blamed of that whole case to the province of Alberta, because the owner of the lake was province of Alberta. So, as while carrying his two young children, he reached a concrete platform and he placed his children on the edge of the platform, proceeded to dive head first into the water. He placed his head first into the water, and without even knowing the depth of the beneath platform. So, as a result, he suffered from a broken neck and he was rendered paraplegic. That means his neck was broken and he had to be live without his neck being fixed for his entire life. Moving on to the factual and procedural events leading to the judgment. So, the plaintiff argued that there were not adequate signs and boards to ensure that the water depth is adequate for the jump. And the defendant keeps arguing that how could a person make a dive without even knowing the provincial depth of the lake. So they both have their genuine points, but the judgment ultimately focused on determining the standards of care owed by the defendant, whether the measures taken were responsible under the circumstances.
Hello everyone, my name is Simranjit Singh. My topic is issues and disputes in McQueen versus Alberta case. In the McQueen versus Alberta case, several critical points of contention emerged regarding the safety precautions at Sycamore Lake, the actions of David McQueen prior to his injuries, and essential legal principle of occupier's liability. Now, let's begin with the breach duty of care. At the heart of this case was whether the province of Alberta had violated its duty of care under the Occupiers Liability Act. Mr. McQueen contended that province was for visitors. He argued that they did not take the necessary safety precautions, nor did they provide adequate warnings about the shallow water that posed a significant risk. This raises an important question. Did the province fulfill its legal obligations to ensure the safety of its visitors? The duty of care requires occupiers to take responsible steps to protect individuals from foreseeable harm. In this context, it's crucial to evaluate whether the measures in the place were appropriate and whether the province adequately assessed the risks of associated with recreational activities at the lake. Next, we turn to adequacy of safety measures. The adequacy of safety measures implemented at the Squamish Lake was a significant source of disagreement. This included the design and layout of the lake, the presence and training of lifeguards, and effectiveness of signage indicating water depth and safety guidelines. McQueen questioned whether these precautions were sufficient to prevent accidents and ensure the safety of guests. Were the lifeguards properly trained to handle emergencies? Did the signage provide clear and understandable warning about the risk? Moreover, were, the, were there enough visible indicators safe swimming areas? These considerations are vital in determining if the measures taken were reasonable in safeguarding individuals participating in leisure activities. Ultimately, both our points of contention highlight the broader implications of public safety and the responsibility of occupiers. They challenge us to reflect on how many safety protocols are implemented and monitored in recreational spaces, ensuring that visitors can engage in activities without undue risk.
Hello everyone, my name is Poonam Deepka. Now I will talk about the another part of issues. The court had to decide if McQueen knowing put himself in danger by diving into the lake. The province argued that since McQueen had been to the lake before, he should have known it could be risky. The law says that if someone knows something is danger and still chooses to take risk, the owner of the place is not responsible if they get hurt. So the court had to figure out if McQueen fully understood and accept the risk before diving, which would mean the province would not be responsible for his injury.
So, hello everyone, myself Johnny Kumar. As my groupmates introduced the case of McVean, in which he got severe injured at Sikkim Lake when he visited that place with his children and friends. So, I'm gonna shed some light on some key consideration about the case. So, first and foremost, the court considered the design of Sikkim Lake, which had a shallow gradient with a maximum depth of about 8 feet. The layout included skimmer platforms that McQueen used. The specific condition of the lake and surrounding area were integral to evaluating the province's duty of care. Apart from that, the court also acknowledged about the previous knowledge of Sikkim Lake. The court examined McQueen's history of visiting Sikkim Lake, so in which they found that having attended the park for multiple times, he was presumably familiar with the environment and its potential hazards. This background also raised a question about whether he should have taken precautions before diving. Next, the court also looks at legal standards in which the interpretation of the Occupiers Liability Acts played a crucial role in the proceeding. The court needed to determine what constitutes reasonable care in a recreational setting and how that standard applies when visitors engage in high risk activities like diving. Furthermore, the court also analyzed precedents such as Warren's v. Camrose, which indicated that while reasonable safety measures are required, so it is impractical to eliminate all risks associated with active recreation. Last but not least, the court also acts as lifeguard and monitoring practices, in which the effectiveness and positioning of lifeguard were assessed, as their primary role is to monitor safety in swimming areas. The distance of the lifeguard stations from the diving area and their ability to respond promptly were factors considered in the context of safety provisions. So now I'm gonna hand over next part of this case to my next group member. Thank you.
Hello everyone, my name is Harmanpreet Kaur and my student ID is 4386602. And moving further, I'm going to discuss with you all regarding the holdings, applied rule of law, and the decision taken by the court on this case. So, this case is all about the Occupiers Liability Act, which explains the duties of property owners or those in the control of the property when it comes to the safety of visitors or to keep them safe. The law says that the occupiers must take responsible steps to ensure the safety of the visitors while on their property, as long as the visitors are using the property for its intended purpose. However, it also states that occupiers are not liable for any risks that the visitors knowingly take on themselves, when they willingly. Now I'm sharing with you what are the applied rules of law to this case. So there are three key provisions related to this. First is duty of care, second it's assumption of risks, and the last is warnings. So first, duty of care, it's in section 5 and it states that the occupiers must take reasonable care to ensure the safety of visitors. Next is assumptions of risks. It's in section 7 and it states that occupiers are not liable for risks that the visitors willingly or knowingly accept. The last one is warnings and it's in section 9. So it says that warnings must be adequate to allow visitors to be safe at the property of the owner so they can take care of themselves. So, what was the decision reached by the Alberta Court of Queen's Bench? So, it was in favor of province of Alberta because it was found out that the province of Alberta has taken care of adequate safety measures, voluntary assumption of risks, and there was no breach of duty. So, firstly, in adequate safety measures, the court found out that the safety measures at Sikkim Lake, including lifeguards, signage, maintenance of area, all these met the reasonable standard required by the Act. Next, voluntary assumption of risks. The court emphasized that McQueen, having previously, visited the lake, must have been aware of the dangers at the place. So it was his own decision to dive into the shallow water without knowing the depth of it. So it was viewed as a voluntary assumption of risks by the court. The last, no breach of duty. Ultimately, the court concluded that the province of Alberta did not breach its duty of care to McQueen, as the measures there were sufficient to ensure the safety of the visitors under any circumstance. So, as a result of this, the court ruled that the province of Alberta was not liable for McQueen's injuries, upholding the principle that occupiers are not responsible for injuries resulting from risks that visitors voluntarily or willingly assumes or accepts. That's all from my side. Next will be continued by the next member.
Hello Professor, my name is Aman and today I would like to talk about the reason behind the court holding, including legal principle and the presented. In this case, the Alberta Court of Queen Bench holding was influenced by the several key legal principles and the presented regarding occupier liability, safety measure, and the voluntary assumption of risk. Here are the main reasons behind the court decision. The first one is duty of care under the Occupier Liability Act, in which the court applied the principle outlined in the Occupier Liability Act. According to the Section 5, an occupier must take the reasonable care to ensure that visitors are the reasonably safe while on their premises. The Act emphasized that the duty of care is The duty of care is context dependent and does not require the absolute safety. The court evaluated whether the province took reasonable steps to ensure safety and the given circumstances. And my second point is adequate of safety measure, in which the court found that Shikuma Lake had the adequate safety measure in, including the lifeguard on duty who were responsible for monitoring the lake. And second point is the design and the maintenance of the lake, which including shallow gradient and the proper signage. Testimonies from the witness indicate that the series indicate at the similar recreational facilities are rare, suggesting that the place in measure in place were sufficient. And the third point is voluntary assumption of risk. A significant factor in the court decision was the McQueen voluntary assumption of risk. As per the Section 7 of the Act, the court emphasized that the McQueen had previously visited Shikuma Lake several times and should have been aware of the potential danger associated with diving into the shallow water. The court referred the principle that individual cannot claim damages for injuries incurred while engaging in the activity they knowing accepting as risky. McQueen's decision to dive headfirst without checking the water depth was viewed as a consequence choice to accept it as associated with risk. And my fourth point is presented case, in which the court considered the presented like one V Camrose 1989 were it was noted that serious incidents in public swimming pool are rare and that enforcing over strict rule can lead to the negative consequences. The case established that is unreasonable to eliminate all risk in recreational activity, aligning with the court finding that reasonable precaution had been taken. The court also acknowledged that every case must have access based on its unique facts and the circumstances, reinforcing for the idea that liability in the content specific. That was my part, and the next part will discuss by my teammate. Thank you.
So in this case, the Alberta Queen of Bench made a final decision that the Alberta Provincial Lake was not responsible for any injury of Mr. David McQueen because there were enough safety measures taken for the lake from the side of the lake to make it safe for dive or safe for everything out there. But it was the mistake of Mr. David McQueen that he predicted the depth of the lake voluntarily, and he jumped without even thinking twice. And also, according to the law of occupiers liability act, the province lake of Alberta they were not found guilty about that. So that leads to the dismissal of the claims of Mr. David McQueen's against the province. And here we go, the case ends on that day, and that official date was on Alberta 21st March 2001. Thank you for your time.